welcome to all of you. It's really always my pleasure as Director of Center for International Law, the National University of Singapore, to welcome all of you to our yet continuing Distinguished Speakers Series of CIL. And today we're absolutely thrilled to have two extremely distinguished international law experts. Our moderator first will be, and those in Singapore well known, and those who do international litigation, Rod Bundy, who's been before ICJ. It lost many courts, arbitration, doing international cases. And our guest speaker, a very dear friend, one of the members of the International Law Commission, now retired, recently retired, Ambassador Vilawan Mangklatanakul, who has been an ambassador for Thailand for many years, and she has extensive experience as a diplomat ambassador in investment and trade issues. And so welcome and thank you for being with us. And so now I have the pleasure of turning over the mic to Rod Bundy to continue this panel. Thank you.
Thank you. Good afternoon, everyone. There's only one distinguished. Is this not working? There's only one distinguished speaker today. I'm the undistinguished moderator, and I'm very pleased to have the honor to be here with Vilawan Mangklatanakul today, who is diplomat, ambassador, international lawyer, member of the International Law Commission. There seems to be an International Law Commission gang here today. I want to set the stage by just giving you a little bit of historical context. Those of you who are interested in international arbitration, and particularly investment arbitration, may be familiar with the famous Barcelona traction case. This was a case for the Barcelona Electricity and Traction Company. It was a Canadian company, but it basically was responsible for the electricity in Barcelona and elsewhere in Spain. And it was the victim of a man named Juan Marsh, who was described as the last pirate of the Mediterranean. He has an extraordinary story behind him, which I don't have time to get into. But at the end of the day, through his machinations, he managed to take over, his group managed to take over the Barcelona Traction Company at fire sale prices for virtually nothing. The shareholders of Barcelona Traction were Belgium. So Belgium brought a case against Spain before the International Court of Justice, alleging the expropriation of the Barcelona Traction Company. And the court in that case rejected the claim because it said that the company was a Canadian company, and shareholders who feel they've suffered damage have to look to the company to espouse their claims. They cannot have a direct claim against the foreign government of Spain. So, no private investor being able to claim against Spain, Barcelona Traction was rejected. I'll just give you a brief amusing side story in that case. My wife's father was counsel for Spain. He brought his 6-year-old daughter, my wife's sister, to the hearings. You've ever been in the Peace Palace, stained glass windows, the judges come in with their black robes. So the 17 judges come in and sit down, and the poor 6-year-old girl thinks she's in church, gets up, approaches the bench, kneels down, and crosses herself. At which point the entire courtroom burst into laughter, at which point the poor little 6-year-old girl burst into tears. It happened that her godfather was the Italian judge on the court. He had the proceedings suspended, came down off the bench, picked up the crying girl, took him out to the court, Peace Palace's gardens for 15 minutes to calm her down. My wife keeps still reminding me it wasn't me. Fast forward, that case was decided in 1970, and even in that case, the court foresaw the future because it said there are beginning to be treaties entered into and multinational conventions being entered into that give a right of private investors to bring cases directly against the state if they feel they've been unduly harmed by state actions or unjustifiably harmed. So the court saw what was coming, although it rejected the claim of the shareholders and the Belgian espousing the claim of the shareholders in that case. Fast forward to today. ICSID has, as of the 31st of December last year, ICSID had registered over 1,085 cases, investment cases. As of the end of 2022, I haven't got more recent statistics, the Permanent Court of Arbitration, which usually administers non-ICSID investment arbitrations, was, I think, administering 118 investment arbitrations. That number is probably about the same today. There are a lot of them out there. But investment arbitration has come under increasing scrutiny for transparency, whether we should have a permanent court with an appellate mechanism rather than these ad hoc tribunals that one finds, and for a host of reasons. And these are, I think, some of the issues that our distinguished speaker, Dr. Vilawan, is going to be speaking to. So without further boring you with stories, which is all I have at my age, I ask you, Dr. Vilawan. Oh wait, can I rescue my glass of wine?
Good evening, good afternoon, good evening, everyone. So thank you for being here, and I'm very grateful and I'm very privileged to be invited to hear you speak today. And thank you, Norman, for kind introduction, and also Lufa for inviting me to spend some time here. So I'm nervous, I have to say. Although I deal with this issue, all the time, but I always get nervous, especially when I have to speak among those who are very expert in the area. Okay, so I try not to do my best, but let's see. We have I'll take you a little bit back because Robert already said that there is an increasing case, that is happening today. You look at the statistics, the untouched, you will see that the cases, ISDS cases is increasingly, all the time. And even this year, there are new, almost 100 cases worldwide. But that's the known case. Because there are a lot of times where there is an investor state case are not known until, it's ends or it's just, or it doesn't go through all the way through litigation process, then you don't have known about it. And many cases, as for our area in Asia and especially in Southeast Asia, we have done a lot of investor state dispute settlement as well. They are increasing here. So we have about 10% out of about 3,000 IAA investment, bilateral investment treaty, and also the FTA, which has the investment chapter in there. We all call it totally IAAs. And that's, we have about 3,000 at the moment. At the same time, for ASEAN, we have about 300 agreements. And then, and we have about 10% of those cases, have been around here. That's what I have known from the statistics from ARTAT. For me, I was involved in the negotiation of bilateral investment treaty and FTA, which include the investment chapter, especially with the UNFTA, the ASEAN and Australia, New Zealand. And if you want to look at it, there is many innovations that we have in there, because we negotiate those treaties during the time that we, in the ASEAN, coming from financial crisis as the Tom Yum Kum crisis. So I mean, you all know that already. And so there are many, I would say, innovations that has been developed there, and it's very happy that it was been taken up by UNCTAD, and it was included in the guideline and in the study of UNCTAD. So that was when investment protection is not what you call why rights of investor anymore, but you have some consideration for each state, to look at it. As a diplomat, when we have extend our relation to other country, when ministers are going to go to see each other, then they will ask, what kind of document they sign. So the first that comes to mind of the officer to offer is the trade cooperation. Secondly, is the double taxation. And thirdly, in bilateral investment treaty. So for Thailand, we conclude, every design, so many treaty, we have to up to 40 treaty that are in force now. And nobody look at it, just spend 2 days negotiating and then you put on shelf and it's become effective and enforced between you. And suddenly, I give you the example of Thailand first, then we have the first case in 2010 where there is a German company was suing Thailand, and everyone was like, what? Where does this come from? What kind of obligation that we have? Unlike the WTO, bilateral investment treaty has been taken, very lightly at the very beginning, and then I think things changed now, especially when we heard with Danielle this afternoon that there are many issues that are involved. There are many other treaty obligations. There are many sustainable, development goal, whatever policy that the government has to take, and that will come into play for the investment. So with that, can I take you back a little bit for those that might not be familiar with the origin of this kind of treaty? Okay. So I'll go back a little bit of the origin of this. I always say that this kind of protection, because my heading today is that investment protection. So this protection, of course, as a diplomat, when foreign national is coming to your country, you extend diplomatic protection to those persons and companies. And so diplomatic protection would be something that you provide to protect foreign personnel and also companies in your country. But diplomatic protection, it already said diplomatic. So you have to go through all these, embassy consideration, you have to go through all these, Ministry of Foreign Affairs, and so it's very involved in the all the time. So with that, there was the conclusion of this kind of treaty that we call Friendship, Commerce, and Navigation Treaties, or FCN that we know. So those treaties would be, I would say, that the foundation for protection of foreign or aliens in your territory. These instruments typically address several issues. First of all, is the protection of individuals and their properties. Secondly, there is the freedom of movement and shipment. And thirdly, right to trade or an established commercial presence or commercial enterprise in the host state. And fourthly is the non-discrimination treatment, which is composed of national treatment and most favored nation treatment. So these two of non-discrimination treatment is far back, from early 19th 19th century. Those go far back, and this has been included in the trade and other aspects of, liberalizations of goods and services as well. And finally, is the access to ports and navigation rights through territorial waters. I think this is because at those times we have been recognized that states have sovereignty in that territory to do whatever they want. So for foreigners who come into the states, they need to have this, free hand a little bit, to exercise their power and their commercial activities. Those are the 19th century old FCN treaty, and later on in 1945, after the World War II, and there has a lot of establishments, trying to bring in the new world order, and investment is part of this economic development, that strategy that is for developing country to gain their independence in terms of economic development and progressive development of their country. So that's coming in another era of the FCN Treaty, and at the same time, there were cases that arrived when the World Bank and trying to encourage more foreign investment into other countries. So at that time, you will see two important developments. First of all, there was in 1959 that we conclude in UN, the UN Convention on the recognition and enforcement of foreign awards, and that gives the leeway for the country to enforce arbitral awards, and foreign arbitral awards, and that was concluded in UN. At the same time, there was the first bilateral investment treaty has been concluded, and it was the German and Pakistan treaty that has been recognized as the first contemporary bilateral investment treaty. From then on, it has been exposed to so many, because it can be a condition as well. It's the informal condition that when you want to have this massive and big project investment in your country, you need to have some protection other than your legal regime that you can provide for protections of others. And that has been the increase in concluding investment treaty. So you will see that the treaty that's still in force today is the legacy of those periods. So some treaty, let's take Thailand for example, we didn't have the investor-state dispute settlement. For the German, which is the first country as well to conclude the bilateral investment treaty with Thailand. At the beginning, we don't have investor-state dispute settlement. So it's only state-state. So with state-state, is not efficient for private investor. And later on, it has been modified. So there are renegotiations to include investor-state in that agreement. We started in almost 2000 that we started to have this investor-state dispute settlement. Although Thailand was very first to be party to the New York Convention. Yes. So let's look at sources of the legal regime for bilateral investment treaty or investment law. There was a lot of misunderstanding. Many people are still, even some lawyers, international lawyers, still ask me that, This is a private international law. It's not a private international law, international law. Bilateral investment treaty is a treaty. It is a law, it's a treaty law. So it's by state and state. But in this treaty, what is the unique feature of it is that it's very wide for investor to bring the case against the government directly through the course of prior consent that the government has already given in this treaty. So it's not the private international law. So like other public international law, sources that we have is the sources that we have under Article 38, of the UN Charter, of the SPT. There are three sources. First of all, it's a treaty that we have been concluded, more than almost 3,000, I lose count of it. And those provide the basis for obligations for states. Secondly, it includes some of customary international law, but that's still be debatable, which already crystallized as a customary international law. Those principles that are still considering whether it is a customary international law is that rule of expropriation, minimum standard of treatments. Of course, there is a different interpretation to that. But this sort of principle is already accepted as a customary international law, except to the extent of it that is still arguable. Thirdly, there is a general principle of law, such as good faith, pacta sunt servanda, due process of law, and even sovereignty over natural resources. All this has been included into this treaty. But the picture has been blurred if you look at all the decisions of the arbitral tribunals. Because when the arbitral tribunal addressed this treaty, if you look at the wording of the treaty themselves, as like it is a contractual agreement. Unlike the WTO, like it is already stated in the DSU and elsewhere that when you interpret WTO documents, instruments and agreements, you have to apply general principle of international law in interpretation. But we don't have that in bilateral investment treaty. So when this case arrives, what's happened is that all these arbitrators just look into the treaty and treat it as if it is such a contract. And so all these will be interpreted. When I was involved in one of the cases that Thailand have, I tried to bring in the state dispute settlement, which already embedded in the treaty themselves, but nobody is going to understand and to use it because it's already using the investor state dispute settlement. So in that sense, this principle has been, I want to reiterate that it still applies to the interpretation and application of bilateral investment treaty or IATs. So let me go spend a little bit of time on the core substantive principle. I know some of you might already familiar with it, but I just want to quickly that first of all, as said, it's non-discrimination. National treatment and FFN is used together in order to provide the same treatment for foreign investors. Secondly, there is a fair and equitable treatment. You will be heard of this a lot in the dispute settlement because fair and equitable treatment sounds good, but it's open up to a lot of interpretation. And during that, instead of, we are thinking of the fairness and stability and predictability of the legal system and business environment is also extended to the right of the acquired rights of the investor. So it has been in the decision when we thinking whether the investor had been treated fair and equitable or not. We look at when we start the investment, what is the expectation, what is the economic expectation of the investor, and that economic expectation has to be legitimate. And that's open to a lot of interpretation and different interpretation amongst arbitrators. Thirdly, protection against expropriation. That's most used to when there is the case arise as well. And this includes both direct expropriation and indirect expropriation. And it could cover measures. When we have the case, it's so difficult to explain to the government that your regulation or your law already passed parliament, because the domestic organs always think you have done so according to the legal system, regulation, law that is required in your country in order to issue certain regulations or law. But they cannot understand it, that this is the measures under investment. The next obligation is the full protection and security. And this again, a lot of government felt that they have done, according to whatever their law, and then suddenly happened. There is a case in Thailand where there was a protest against certain company with the problem of the oil spill, where it has damaged certain area of the beach. Thailand, we have beautiful beach. So the local community, oh my God, this beach has been tainted by this oil spill. And there was like protest, and the protest would get escalated until there was some violence in that. There's a fire and set fire to the plant, the old plant. And what they do is that, what we are considering then is that whether the government had provide full protection for that investment or not. Now against all these protests and so that is also one of the obligations. Another obligation is the free transfer of funds. When you invest in certain country, there might be obligation for you to be reinvested in that country and cannot bring it out the fund that you have been invest or profits that you have acquired from your investment. And this guarantee that you have to allow foreign investor to transfer their funds out of the country. And finally, there is umbrella clause where you have to respect agreements between. So most of the case that we have is involved in the licensing or even procurement agreements or even other kind of agreements. And that agreement has to be respected, and breach of that agreement, if you don't have the way of settle it or it's not being settled, could escalate to the breach of the bilateral investment treaty itself. So those are principal obligations. But the most efficient tool is the investor-state dispute settlement. That is a procedural in itself, but it's provide, very effective tool. Like the WTO, because we have BSU, then it's when very effective. You need to have the case to reward in order to remedy the loss that you have. This is again, investor state arbitration has been a very effective tool, and it has not been used very often at the very beginning. But in the late, I think, according to the UNCTAD statistics, I think the escalates, in the past 10 or 15 years, this last decade, where the case of arbitration, investor state disputes escalates. And that has proven to be effective tool for investor to bring the case against the government. So now, can I go on to the next issue that I'd like to address today? When there is a cases that has been, there is a lot of money involved. There is a lot of policy. There's a lot of politics involved when you involved in this kind of cases. And increasingly, it's not only the European country or the local country that has been exporting, capital exporting country. Now, investment has been mixed and reversed. There is many cases that Thailand, for example, I take Thailand because I'm close to it. I'm sorry about that. But we have become, claimant. But of course, there are so many. I talked the other day that we like it to be, easy way. So most of them end up at the negotiation and consultation stage. So the case was not, escalate into a full case. But we have used our investment agreement as well in trying to solve investment dispute that we have, and we are going to invest abroad. So investor states, country in Europe has been sued by a lot. You see the number of cases that the government has been said. So now it's not, one side already. It has been escalating cases, on from both sides, developing the developing country. There is nothing as a north and south anymore in the investment arena. There is the thinking that these investment dispute settlement mechanisms create some double standards in international law. First of all, it is preference rights for foreign investment. These rights will not be enjoyed by their domestic investment, and taking the comprehensive and complex way of doing business these days. Local companies are complaining that, why you don't have this, right of protection, you have to go through all this court, the administrative court, you have to, spend here, and then you have to come to the Supreme Court, to avoid enforcement and those sort of things. So why are these rights solely for foreign investors? Secondly, there is an imbalance in access and outcomes. ISDS is most frequently used by the large company which have more resources, both technical resources and financial resources. You will see that all these cases will be very expensive. If you read in the news, the latest case that Thailand have is that we end up settle among ourselves, but each of us have to take care of our own expenses, and you can look at in the news of the expenses that we have to pay. So it's quite costly, to have in this, and the company need to have ability in order to bring the case against the government. Thirdly, it's undermine what is so-called the state sovereignty over the national resources and also the public policy. we are talking about the climate, this become because state also has obligation under other climates or environment treaties, which is a treaty obligation as well. So how state going to do all this? And it means that it cannot, regulate in terms of this. What happened again in Thailand? There is a case where we have implemented these new regulations in compliance with the Paris Conventions and all this. And then we need to have the company to do the environmental effects assessment. And we implemented. And that's when we implemented, it's go across the board. And then the company that's already operated said that, I already operated, it's my right, it's not required before now. And then the government put a lot of burden on this because our company, our factory have to be renovated, upgraded to do all this. And there was the threat at that time, to be the case, investors face with case as well. But at the end of the day, the way that we do, we try to settle and then give them, some periods of time for them to do it. And we have not loosened a little bit of the regulations. So it's settled there. So this could undermine sovereignty and public policy. Another issue, thirdly, is the lack of transparency and consistency. So there are many ISDS procedures that has been challenged, that criticized that there might not be transparency, this might be limited, into certain area of, group of arbitrators, and arbitrators can have double hatting, they can play, this role and the other role. And what about if we have the decision, we don't have anywhere to appeal, like in the WTO. When we are thinking of this assessment, we only think of the WTO as a comparison. And that the powerful investor and those who are very well equipped with technical knowledge might be able to have the more leverage, advantage in the case. I, as a lawyer, when I get to know the government, and I say, well, because claimant have plenty time to prepare for the case. So, of course, they have to calculate and assess already that there should be a chance for them to win the case. Otherwise, they would finish before that. So the government have to prepare themselves, that they have to be fighting a very hard case. And that is very, believe me, very difficult to convince the government agencies. For double hatting, although it's why we think this is a problem, but for me, I felt that the problem is that we don't know how to choose arbitrators. And we just look at the record because for Thailand, we are not very, used to all the international litigation, I have to say. And then we just make your choice, sometimes might not be a correct choice. Finally, it can be seen as a sectoral and geographic concentration, that there is more involvement in energy, infrastructure, natural resources area, and it could be seen as a north and south, over north and over south on this. And even I was, I had a privilege to share the panel at Fabio a few last year already, in Geneva on considering of this double hatching in international law. And we have looked at the energy agreement of Europe, and a lot of countries are already pulling out from those treaty. because those usually, of course, conclude during the time that there are a lot of investment in various countries of the world in order to secure energy resources. And please say, the UK has already withdrawn. Well, Germany, I think, already withdrawn. And that could be something that is seen that if we don't do anything about this investment treaty, then there might be a country that withdraw or terminate. There is a lot of cases that has been thinking about terminating this treaty. With that, how I'm doing, lose track of the time. So,
8 minutes or so.
okay. So I'll go to the next attempt that we are trying to have at the moment is the ISDS reform. And I will talk about the ANSI trial, because ANSI trial has been working on this since 2017, and then there is the 3 phases that ANSI trial have been doing until now. First of all, is identify concern about ISDS. Secondly, is assess whether the reform, ISDS reform, is desirable. And thirdly, develop concrete reform solution. So now it's in the 3rd phase of the trying to develop concrete reform resolution. Of course, there has been so many attempts at UNCTAD, OECD, trying to have the multilateral investment treaty where all these obligations are aligned and in the same level of protection. But those attempts has not been successful. So for ANSI trial, it's all, because of mandate, its mandate is narrow, because it's only concerned with the procedural aspect of investor status and settlement. So what they have been trying to do is that currently there are they have draft certain instruments. First of all is the Advisory Center on International Investment Disputes. And this mirror, we have, this is a proposal that Thailand and Netherlands and certain countries were put to the consideration of the working group, because we felt that as a developing country, as I said, we are lack of resources, we are lack of expertise and technical, knowledge. And we have learned that, since we have PSU at WTO, and there was there is the advisory center that providing assistance for those states, and it's helped developing states to be able to participate in this litigation more and more confidently. One aspect that is very important in a country like us is that you might be liable personally to loss of the government in the litigations. That can happen in certain countries as well. So that's made it very difficult. You have to be responsible who you choose as the arbitrators. If that arbitrator went wrong, then whether you have this, any connection with them. It's all a lot of these investigations and explanation that you have to go through. So to have a center that is neutral and provide assistance to member states, it would encourage and support at least the government to defend the case more transparently and confidently in that. So we copy that and then propose this to the ANSI trial, and the progress has been very good. At the moment, they are almost concluding it, and And there should be a center for that. Of course, Thailand proposed ourselves as a host country to this center, but there is other countries that are proposing this as well. So it has gained a lot of interest from various countries that this kind of center will not reduce the case, but it will encourage more cases that's going to be, neutral and more confidently deal with by the government. So that's what first effort. Secondly, they felt that because arbitration is ad hoc, except of course exit arbitration that just has all inclusive system. However, there's so many countries that are not member to the exit, including China. So we had to use ad hoc arbitration, and we felt that some countries felt, especially for Europe, they want some standing mechanism where which is called multilateral investment court. That could be some permanent body and some permanent or at least listed arbitrators and experts in the area to provide consistency and correctness and to reduce this fragmentation of decisions between different arbitral tribunals. Thirdly is the appellate mechanism, which is also proposed by the EU countries, and EU, of course, has included this kind of mechanism in their bilateral or multilateral FTA already. And there is some, although substantively this has been progressed very well, but there is some reluctant and some countries that they are not, want to have this kind of mechanism to them. And of course, a lot of countries, again, worry about cost of maintaining this, international institution, and taking account that, even now, UN has been in a problem with the financial crisis and the liquidity crisis, and if they are setting up something like this, would be very costly and to the member state. There is a code of conduct on the adjudicators. This is directly to the arbitrators, to deal with the problem of independence, impartiality, double acting, conflict of interest, and the ethic of the arbitrator and judges in investment dispute. There's also some attempt to provide rules on procedural. This is on the rules of third-party funding, security of cost, dismissal of privilege claims, and multiple proceedings. These are dealing specifically to the mechanism, to the procedural to the process of the arbitration. And there is the dispute prevention and mitigation guideline that in order to avoid the dispute from the very beginning, and also, of course, the inclusion of the promotion of the use of mediation and also negotiation solution, to this to resolve the dispute has been also encouraged, and this is in the work of the ASEAN. So ASEAN has been focusing on the procedural on this. Apart from ASEAN, of course, ICSID has modified the rules in order to provide better procedure to the bilateral investment treaties disputes. So can I move on to the next issue that I'd like to talk about is the right to regulate. I think you heard of this word, more and more these days. This word, although it's come to intention in the internet investment community, lately, but the principle itself has already been, developed, through the years. I take back a little bit, to I have the history part that investor state has been the 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 concern that this treaty will not provide the government with the opportunity to exercise their sovereign rights, in governing them and pursuing certain policy has been a problem for the government, and there is many attempts trying to put this right to regulate for the government into the investment law. I would say at current stage, it become more apparent at the current stage where they think that where in the cases that we have, most of them are involved in the policy of the government. And again, with the emergence of new treaty on the obligations of state in climate change and environment, has put obligation to state to implement certain mechanisms and certain regulations that to comply with those agreements and might affect the right of investors. In Asia, when we have, I take you back to the UNFTA little bit, when we negotiate that, we have that is the after we have the Tom Yum Goong crisis. And when we're talking about protection of investment, we try to narrow down, what's investment disputes, and to be narrowed down and to be clear. We have included a provision like investment dispute means what? It has to mean that a breach of certain provision of the agreement. So we identify provision to that. We put in the exception clauses, of course, borrowed from the WTO as well. That general Article 20 general exception, sometimes we incorporate that into our treaty. And to certain time, we even have a specific provision on right to regulate, just to allow, just to state that the government is free, to regulate in certain area that they have policy to. But of course, that has to be undiscriminated, and it has to be due process in that. So there are various tools that state has been using into their new treaty. But the problem is that when we want to renegotiate the old generation treaty, that's another story. When we negotiate FTA, the new treaty, this will be included in there. So what leaves us is that we have two treaties for one country, at least. For Asia, we have ASEAN, we have the investment treaty, also we have provision. Many of us have bilateral investment treaty, we have FTA, so it could be like treaty shopping. So it doesn't help, because investors will choose the treaty that will be most beneficial for them. In our case, latest case, is we go back to use like, Thai, Australia, and bilateral, the very, very first generation of FTA, which is, have a very weight position on that. And that's the problem. So whether this is the right time or not, then we started to do some drafting on that. So that's come to the last point. That's my thinking when I was campaigning for the International Law Commission, and I'm come from the investment background. So I like to have the International Law Commission to look at the economic issues. Of course, it's not popular because many oppose me, even my colleagues, oppose me. No, that's not the correct way, that's not the wise way, for you to campaign because you are pursuing something that's unwise. But it gave me a lot of thoughts, and then I want to be in the International Law Commission, and I like to post something that I think is useful for many countries. And so I did table very ambitious proposal at the first year, of course, in the investment protection. I tried to find a model, and the model, more like, a multilateral investment treaty. But that's because I'm a diplomat, I'm a negotiator, so I put, like maximum claim, to that. And of course, I'm now reducing it. And this year, I will table the right method to the ILC for the consideration, but it's up to the Commission to do that. Why I'm doing that? Because I went back to look, International Law Commission is there to codify and develop law for member states of the UN. And if you look back to the older days, there are many work of the International Law Commission that's already touched on the economic rights of states and various countries. To take example, draft article on the law of the sea in 1956 already addressed certain issues about exploration and exploration rights, of oil and gas and fishery already. Touched a little bit on that. Later on, we did draft the Convention on Arbitral Procedure, but later on, because UNCITRAL has been established to specifically deal with international trade law, so the work can be shifted to that. So that was the argument with somebody with me as well, that you can have UNCITRAL to do it. But as I already explained to you, UNCITRAL only deal with the procedural. It's my belief that the problem is in the treaty itself, the language of the treaty itself. That was the work. Now, we are talking about, there is an article on state responsibility in international lawful acts. Of course, it deals with the general principle where state is in wrongful act. But those state wrongful acts could involve expropriation and certain that can provoke all these treaty obligations, and it might end up that a state might be sued by the government and private under investment treaty. And I'm sure that there's something that is has been there. And there is a most favored nation has been drafted in 1978 and 2015, and we haven't used that. And there is a proposal, standing proposal on fair and equitable treatment, but that was not yet it's still in the long-term program of the ILC. So with that, I have to conclude that if you like, I read it a little bit for you to study on. I'm working on the final proposal to be tabled this year, and I will share with you later on if you like to see it. Thank you very much for your attention.